Yes, the gavel is back. Good morning, haters. It is time for another episode of I Hate Real Estate, and we've got the gavel back in the office along with Mr. Kendall Grooms. How are you?
Good. We got it recovered.
I know. It's been recovered from evidence.
We call that replevin.
Replevin. Mm-hmm. Is there a squiggly line that describes what a replevin is? Yeah. What's a replevin?
It's where you go get something yourself or you have somebody do it for you.
Terms and facts. So now that we have the aficionado gavel back, how was your weekend?
It was good.
Did you do anything real estate-y?
No.
I did.
I smoked something.
What?
That's what I told my kids.
He's an attorney. You can't smoke stuff
like that.
I
told my kids, I said, we're going to smoke something today. And they're like, Dad, you told us not to do that. And
Smoking
I was like,
is bad.
I know. That's what we're doing on the grill.
Was it a brisket?
No, it was a pork butt.
Okay, so why? What game?
Huh?
What game were you watching
Nothing.
that you smoked?
I got a new grill, so we wanted to try it out.
Oh, okay. And there was golf this weekend?
No.
No? You didn't watch golf?
Oh, yeah.
Yeah, you watched
We watched
golf.
all kinds of sports on TV.
Okay. I was going to say, there had to be some sports going on in your house. In my house, there's sports going on, but right now there's an infant, so no one can hear it. So it's good. But we're going to start this morning talking about the foundation, which you're going to clear up my analysis of this case because apparently I'm not the attorney. But I was reading through this case last night, and you can kind of walk me through what happened because I sort of misunderstood what happened to the agent. So I'm going to let you start from your review of this case, and then I'll jump in.
Okay. Yeah, you sent me a case that talked about the title of this realtor being guilty, but it was far from guilt.
Like a traitor, I blamed the realtor.
Yeah, that's right. So what happened here is it's the classic situation. One of the first episodes we did on this podcast was a nearly identical case to this, except in that instance where someone had gotten a report done on a foundation, the realtor was the actual one that got the report done.
Yeah.
This is one step below that where the people bought the house. They had a company come in after they started seeing some foundation problems. And as it turns out, the former owners of the house had the same company come out to address these foundation problems. Well, the seller's disclosure only disclosed that there was a minor cracking issue in some of the walls and the sheetrock, and that was fixed, and they had experienced no other problems.
Normal settlement. Yeah. So, yeah, if you ever heard the term normal settlement cracks in your experience in real estate, tune in for the rest of this episode, okay? Continue.
Yeah. But the people filed a suit against the former owner, which is typical, but they went a step further and filed a suit against the agent as well. And I can't tell from the way that the appeal, this is a non-published case, which means a lot of the details are missing from what actually occurred at the trial court level. And it's also a second appeal. This case was appealed twice.
Who appealed it? Is it the agent that's appealing it?
No, the homeowner appealed it because the court dismissed the case. So I can't tell if the broker was sued also, but the agent was certainly sued. And they sued on fraud, claiming, and conspiracy and a couple other things, claiming that the agent also knew what the homeowner knew.
Well, and so disclaimer, if you are a listing agent, typically you have a good relationship with your seller and they're going to tell you everything that's gone on with the house. But it's also it's good for you and it's indicative of your role that when you go to the house as a listing agent and you see cracks and things like that, that you ask the questions before you even give them the opportunity to fill out the form. At
Correct.
least so you in conversation can get that out.
Well, and then you can sign an affidavit later on if something like this happens, like this agent did that said, I had no knowledge of it. And if they can't prove that you had knowledge, there's a lot of things they can't prove. And so what happened here is they sued for fraud. They sued for conspiracy. And fraud is an intentional act. It means you knew or you should have known, and you then made a misrepresentation about the condition or what you knew in order for someone to rely on something and take an action, in this instance to buy a house.
Yeah, and just note to self and you that we're going to talk about reasonable care related to this in a minute too, because go ahead.
But they go forward with the case, and it's the classic, here's the disclosure form, here's what it says. Now this agent, I took it from the way that this opinion was written, that this agent had some background in construction as well. Because they talk about specialized knowledge in construction and should have known if there were cracks, that there should have been, that there were possibly other issues and should have looked into it further. But that's where it all fell apart for them was that the judge came back and said, well, the seller's disclosure says that there were cracks in the wall. If that was indicative to this agent that there was a problem, it should have been indicative to you as well and everybody else that looked at the seller's disclosure. So in my mind, what happened here was that the forms that this is an Arkansas case, the forms that Arkansas utilized worked for the agent's purpose. Mm-hmm. Now, the homeowner is probably hosed here, big time.
Yeah.
Big time.
It's really,
and I don't know what the outcome of that was, but the homeowner is not going to be in a good position.
Well, and to be totally forthcoming, sir, there's actually, it's funny because I'm not involved with it, but there's an agent of mine that has a kind of a very similar scenario too, where it's like the homeowner knew something and they, they've got their own attorney and they're figuring all that out. But the point is that the same scenario was the level of disclosure that the seller has made, and then the agent's ability to take reasonable care of the client with respect to that knowledge. So it's like, if I know that you had this looked at, for me, I want to go and know exactly what they told you. What does that report say? Because as the agent, it's better for me to be fully informed than it is for me to know that you had someone come out there, but I don't know the results of it because it looks like I'm lying. Like, why would I, as an agent, have somebody go out there, get the report, talk to the seller about it, be like, I don't know. I don't know what happened.
No, there's very likely some underlying thing. I mean, this person that bought the house may be right. The agent may very well have known, but there was no proof that the agent knew.
No, and that's but the thing that kind of brings me back to what I thought was a positive from this is like what you said about the forms protecting the agent is that the agent's reasonable care of the client was, as the listing agent, to engage the client to list the property for sale, to advertise it, and then in that contract also list for a specific price with these particular pictures on this particular date. And then she asked the seller disclosure to be filled out. At that point, she's really done everything she's supposed to do as a listing agent. When you go under contract and your due diligence period happens, it's 100% the buyer's responsibility, assuming that they check that box on our form, that they get an inspector and that they go inspect it to their level of comfort. And if they move forward to closing, it's an indication that they are in agreement with you, that they accept the house in this condition, as well as page 4 in the URSA, right? Mm-hmm. So did any of that come up with
Absolutely.
You accepted it?
It did. So what occurred here, the reason this is a second appeal is...
better than new condition.
Yeah.
Sorry. Just to be fair, the MLS listing says it's better than new condition.
And that was what they said was a fraud, was that this better than new condition was a fraud. And they actually state throughout the opinion that this was just puffery to try to sell and advertise the property. It wasn't a statement that was intended to be true about the property. And the court bought that argument that it was just puffery. And
I think there needs to be a disclaimer out there for agents who are writing really good copy, because the idea is that you write good copy to get people to click on your ads. But if your copy could lead to a lawsuit,
you better be careful with how far you go with it. Yeah. Well, so
anyway,
we have... there's a thing called a final order. In this case, references a final order. If you go to trial or you have anything happen in your case where the case is over and you're on to the appeal, if you don't get an order entered by the court, some kind of finding on every single issue that's subject to the appeal, then your appeal will be dismissed and sent back for entry of a final order. Then once that final order gets entered, you can appeal it again. So that's why this was done twice. So these people sat around for probably a year waiting on the first appeal to be decided, only to get told, go back and get a final order and then wait another year until we decide it again.
So what about the agent in that time? Is she allowed to work?
Yeah.
But if she had found guilty, or if there was a question of guilty?
Yeah, because the case was dismissed on summary judgment by the judge. There was no guilt at all found upon the agent the first time around. But what happened here, there's a rule in Arkansas called the mandate rule. When something gets decided, it goes back down. It doesn't stop you from changing what you previously alleged. So this homeowner saw the writing on the wall with respect to the agent that it was not going to go well in court the second time around. So they actually amended their complaint after getting dismissed on appeal and came back down. And this is where it kind of goes off the rails, is something different than what I've seen before or done before and I'm surprised that this is not a published case because of it, but they actually allege that the agent was negligent in investigating the condition of the property.
See, this is where I'm going to, this is why I sent you the message last night. Like I titled the episode and I'm just like, yes. This is why.
And so the agent wasn't ever found guilty of anything, but so they go back and they amend it to be negligent. And said that this agent had an extra duty to investigate the condition of the property and find out everything about the property. I mean, it's almost like they were accusing the agent of, you need to go be the one that goes and hires an engineer to look at the property. You need to get a home inspection of your own for the property. And the court obviously didn't buy that. and later dismissed the case because there was a lack of knowledge. But they actually cite in here the real estate regulations, the commission regulations. We call them the 8s and 10s, about dealing honestly and fairly, as to this argument that you have to fully go in and investigate every property that you list to make sure that the seller is telling you the correct information about the property. And it's none of the forms say you have to do this. It's impractical to have agents do this. Arkansas law flat out says that an agent does not have a duty to investigate the property for anything where the homeowner might be lying. So I don't know where they were going with it, but they just tried it in a different format through this negligence.
They just removed fraud and made it negligence. But I think the reason that they're just devil's advocate, because that's my job, the agent had to go through the process of, if the buyer requested what's going on with the foundation. Typically in the due diligence period, the listing agent would allow for a structural engineer no, of course, they wouldn't be the one to contact to set that up because they're the listing agent and their responsibilities to the seller. But as the buyer, I go in there, I'm going to buy the house. If I'm concerned about that and I send an inspector in there and he goes and looks at it and comes back with some findings, and then I ask the listing agent if they knew anything about it, and they're like, I know he said this. We had the same company look at it. This is what we think. We don't think it's as big of a deal. I mean, how do you tell the difference between who's smarter in that situation?
That's conflicting with the forms as well.
And especially if she had a construction background, because she has some kind of construction background and she makes the buyer comfortable, or the buyer's agent comfortable with the language that she uses related to the foundation repair. There is a lot of ways for this to look like the agent has the knowledge to answer the question. And then additionally, just saying, kind of is our responsibility, though, to make sure that we investigate all the way down to the reasonable care of our client. So where's a buyer's agent in this situation?
I have no idea. It doesn't make any reference to it as to what's going on. Or it doesn't even make reference if the buyer did have an agent.
Well, and I'm thinking the buyer either didn't have an agent or they liked their agent a lot and didn't want to bring them into the situation. Yes. But wouldn't the reasonable care of the client on the buyer's agent even come into question? Or wouldn't you have questioned it if you were the attorney? Or am I just being
totally
ridiculous?
Depends on who that agent is. I mean, if that agent is a brand new agent,
but they still have reasonable care.
I know, but they may not know what their reasonable care is. You have to have some level of knowledge. But if it's a seasoned agent who's had experience with construction sales, with any kind of residential transaction, then you would think that agent might be held to a standard as well.
Yeah. Okay. Well, listen, friend. Let's just away from this case, let's talk about your house. Okay. I'm your agent, right? And if we go into a house and you see cracks, what's Jamie going to do? Jamie's going to go all the way down until she gets a hold of Barrett, and then she gets Barrett, and Barrett sends out the Ackley guy, and then Ackley looks at it. And then, so these are all our local people.
And in the meantime, you're also sending messages to the buyer's agent saying, hey, ask your clients what's up with this.
Also extend due diligence, because none of these people are getting out there in 2 days. But I'm going reasonable care, right? All the way to the point where I understand. I guess that's the reason I want to know where the buyer's agent was, or if there was involved, because it feels like if there was any sort of negligence, it would have been on the part of the buyer's agent for lack of reasonable care, right? Just proving my point. But I think, you know what I mean? I think that was the one thing that could have been brought to light, at least if there's two agents, you have two different parties that are representing each of them independently.
And we don't have any reference in this case whether there was one or not.
More than likely it was probably dual agency.
But that's not referenced either, and you would think that would be important here.
Really important, because if they have some sort of legality or some fiduciary responsibility to the seller, and then they're dealing in a situation where they have the buyer and or the buyer's unrepresented, it becomes even more imperative for the listing agent to have that level of information. And I think this is important because at the end of the day, anyone can sue anyone. So as an agent, you open yourself up to being sued every time you sign a contract, and you need to know what are the repercussions of this and what could they possibly say I knew or didn't know based on our prior conversations and with respect to the documents that have been filled out by all the parties.
And this case in particular, along with the negligence, they alleged all these things about breach of implied warranties. That's something that Arkansas has in every transaction, or all these different implied warranties that are out there. But the as-is clause, when they signed the inspection, repair, and survey addendum, and when they completed their inspection, well, it's in conjunction with the IRSA, when they completed their inspection and signed to that, the court found that since the ultimate transaction ended in an as-is clause, or the buyer taking the property as is, that it removed those warranties, and that the agent wasn't responsible under that theory either.
Well, see, that's the one part that, that is the part that made me rewrite.
They ran the full story here on this opinion of a case like this. They tried it from an intentional standpoint that you knew and you didn't tell us. They tried it on a standpoint of you should have known and you didn't do what you should have done to find out. And then they did both of those on the front end. And then on the back end, they came back and said you intentionally breached these warranties, but at the same time, you had an additional duty of reasonable care to go forward and try to discover what all was going on at this property, and you didn't do that either. So really, they tried this from 4 different fronts. And then on the 5th, they tried to tie, whether the agent did anything wrong or not, they tried to tie the owner's knowledge back to the agent through a conspiracy claim. And the way conspiracy works is you have to have a conspiracy is not a standalone thing. If you and I conspire to do something that's completely legal, even though it's conspiracy
to dominate the podcast
exactly
world?
It's not legal. That's not a conspiracy that the law cares about.
No,
they don't care. But a conspiracy has to be something that's done intentionally
to damage someone else, right?
It has to be an intentional conduct. You can't conspire to commit negligence, because negligence is
a passive action.
Exactly.
Right.
Exactly. And so you have to have some intentional act. And so the conspiracy was never going to fly the second time because they didn't allege any intentional act in the conspiracy.
It just kind of there. Now I want to dig deeper just because I'm like, where's the other, now I want to know where the other agent is. And that actually explains to me why I sent this to you misjudged too, because when I sent it, I was thinking in my mind that something different was going on with that other agent, but 5 different times. And this is, I think, another good point as an agent to remember when I brought up the whole everyone can sue everybody thing, making sure that your state in Arkansas, we're very fortunate that we have a really amazing contracts here and people use them to teach other people how to do real estate. But if your state doesn't have those kind of forms that protect you as an agent and because it's Arkansas Realtors Association who works on our forms and they protect us as agents. So there's a lot of things in there that cause us to be protected sometimes without our knowledge until later on we're in this kind of situation. We look back at the form and the agent's protected. So make sure that you're reading those contracts with respect to what your responsibilities are and also what you can be responsible for.
Yeah. This whole thing to me is a catch-22 for agents.
Well,
because you have the Supreme Court telling you on one side that you can act negligently and even make a misrepresentation or not get knowledge that you otherwise probably should have gotten, and that's okay under the Supreme Courts. But then the Real Estate Commission on the other side is telling you that you have a duty of honesty and fair dealing in all transactions.
Reasonable care.
You have the duty of reasonable care. You have the duty to get all information that's reasonably ascertainable. So you have two sides here where on one hand, if you're trying to avoid a lawsuit, the Supreme Court's almost telling you, you don't have any duty to investigate. You can ignore something completely that you don't have knowledge of, explicit knowledge of. As long as you don't make a misrepresentation of something you have knowledge of, then you have no liability in the court. But the Real Estate Commission is telling you, you can't do that. You can't just ignore everything. You have to actually give some effort to assist the parties in the transaction.
Well, and I agree on the Real Estate Commission side of it, because I feel like for me, and this is one of the reasons why I think it's important for good agents to be good agents, is that you're like, when you say seasoned, there's a difference between new and seasoned, but all of them should be ethical. And I think when you learn in real estate school that it's your job to take reasonable care of the client, you have to take an investigative standpoint on the property that you're dealing with. And for me, it started out in measurement just because my background was appraisal, so it lent itself there. But when I started having those kind of issues, like foundation issues, I caught myself in the first couple of years. I'd see settlement cracks and I would just make the assumption that they were settlement cracks. And we'd walk through the house and the buyer would say, "What are those?" "Oh, they're probably just settlement cracks." Had we gotten under contract and gone through a disclosure situation, there was issues beyond settlements, then I'd really be looking stupid walking through the house and going, "Oh, our settlement cracks." But it's one of those things in those first few years, you hear those terms, you start dropping them around. And then if you're not being very, very careful as to what you say, what you know, and what you deliver to the other side, you end up in a 5-appeal lawsuit trying to figure out
well, you have to
how
think
to stay
that
innocent.
this is I had this language highlighted from the Supreme Court, because when I read it, I thought to myself, I was like, the Real Estate Commission had to have read this and just cringed when they read this statement. But it said, this is the Supreme Court of Arkansas talking. It says, "Finally, we address the grant of summary judgment on the appellant's negligence count." So what that means in essence is that the court told the homeowner, you don't have a negligence case. They threw it out. Okay. But they say, which, as pled by her, averred causes of action for negligent misrepresentation, negligent concealment, and simple negligence for failure to ascertain and disclose the defects in the property. So it's the 3 different levels that we talked about. You had all these different types of negligence. You either made a negligent statement by saying that it's better than new condition, or you made negligent concealment in that you should have known something or used reasonable care to discover it, but you didn't, or just the simple negligence, meaning that they just completely overlooked their reasonable care, didn't perform their duty. The court this is language that I know you like because Judge Huckabee did something like this in a case where you testified for me. The Supreme Court says, we quickly dispose of the negligent misrepresentation and concealment counts. Our Supreme Court has stated that Arkansas does not recognize a cause of action for negligent misrepresentation. The appellant has advanced no argument as to why either this cause of action or the similar cause of action for negligent concealment should now be recognized. And that's it.
I do love that language, but I also love that it's like, no, under no circumstances. It's very simple. It's very like, sorry, I know that's your job, but I got excited.
That's exactly what it is. And that's where I think it's in conflict with the Real Estate Commission regulations in some cases, some issues like this.
Well, and I think just in our, like, we have a certain level that we expect too with the people that we work with in this market. And there's some very good agents in this market who are very, very thorough.
I mean, think about the problems this could create if you say, hey, if somebody tells you there's cracks in the sheetrock, some homeowner says there's cracks in the sheetrock, it's no big deal. And you say, okay, we're good.
That's not okay.
And that's exactly what this is saying is okay.
But it's in conflict, and I get it. But luckily, we have one of those states where I don't think we have to worry about that so much because if it comes down in Arkansas, it's going to come down like that.
Yeah. Well, and the forms worked here because ultimately they told them there's cracks in the sheetrock. And like I do, that if you say there's cracks in the sheetrock and they write notes at the bottom that says these have been repaired, everything's okay, you still have a duty to inspect that and investigate that on your own independently. There's all kinds of disclaimers in the forms that says you can't rely on a representation of the homeowner. The homeowner is just giving you what their knowledge is.
Right. And this is the other thing. Sometimes people live in houses and they don't know what's going on with them. And I think this is a really good point to bring up because sometimes, like my husband, I moved into our house years ago after we got married, and I was measuring it because I was showing him like how to measure a property. And I go, yeah, it's this many square feet. And he was like, no, it's not. It's this many. I was like, oh, no, that's not square footage over there. And so all of a sudden the house was 250 square feet smaller. And it was like this huge misrepresentation in his opinion of like, hey, she didn't tell me that wasn't square footage when I bought it. Well, it's been 5 years. You're past the statute of limitations. I don't know what to tell you. But the point is you find those defects and it can really affect everything, not just the value, but your experience of purchasing the home. And I've never seen a first-time home buyer run out of a house faster than when they see settlement cracks because they think immediately it's a foundation issue. And sometimes it can be. So
and these people were told about the cracks and didn't do anything. Now, you've got the underlying problem here that there's a report that this homeowner got saying that there was foundation problems with the house, but...
Well, evidence helps. And that's, I was about to say, like the other case that I've been working on, the one we talked about before, every case that I've ever seen this happen in, typically how it happens is like how they get found out basically is that same company or a related company goes out to look at it and they pull up the address in their database and they figure out they've been there 3 or 4 times before. And they're like, what do you mean you've been there? The homeowner said there was no issue. And you're like, oh, no, we've been there. We've tried to repair it. We've tried to jack it up. And then the buyer figures out that there's been some concealment effects at that point.
We've talked about this before and we probably need to discuss it again because it's important because it'll prevent lawsuits like this from happening. That's what we're here to do, Kendall. Slow down your business. So destroy the legal business.
Yeah, but we're building mine, so that's all.
On the owner side of it, if you're reading through the seller's property disclosure and you read a question, and reading that question triggers something in your brain of, oh, I remember this might apply to that, but is that going to be something big enough to list or not? What's our answer?
Write it down.
Yeah.
Write it
list
down.
It. And if an agent, the rule of thumb, I'll never forget, I had an agent one time who was just a witness in a case, and we took her deposition, and the question was asked to her, if a client calls you, if someone who's a client of yours who you've got a property listed calls you, and they ask you, it doesn't matter what it is. If they say, should I list that on the seller's property disclosure form? The answer is always yes. Every time, it doesn't matter what it is. If they thought something might apply and they call you and say, should this be listed? The answer is yes.
Well, and it's kind of like the one I've actually got a listing today that I'm thinking about because I'm like, wait, I just put that on the market and I did notice that there was a crack, but I didn't see his answer on the disclosure. So I'm going to double check that. But it's one of those things as a new agent, especially, you cannot take enough care of your clients. And over time, as you get better at the business and you get more and more understanding about, for me, like we've talked about before, and with Kindle with the law, you know the terms really well. You've practiced for a long time. You get really good at it. Then it becomes second nature. But in the beginning, if you don't build in those practices of really researching and endeavoring to solve the issue that's in front of you by understanding it kind of you will never grow as an agent. You'll never get to that point where your client can look at you and say, okay, even if there's a crack, I know she's going to get all the way down to the foundation and figure out what's going on with it. Anything in my power, I can do it. Also, when you're purchasing a home or you're advising clients, foundation, roof, electrical, plumbing, HVAC, we never brush over those things. Those are big 5. Those are the 5 things that affect your property value probably more than anything else. So please do not look over those items.
And those are the 5 things that have more problems than anything else.
The 5 things that cause the most lawsuits. Yep. And the realtor.
Did you say foundation?
I did.
Yeah.
Yeah. The bottom and the top. And then everything in the middle. That's what causes the problems.
We get more lawsuits over foundation than anything else. More calls. I can't say we filed many lawsuits because a lot of them aren't. The cost benefit is not there for somebody to do it. But we get more calls about foundation issues than anything else.
And I'd say that that's the same experience I have as an agent because people are mostly concerned about that. Now, we're in the rolling hills of Arkansas. There are some sandy pieces of land around here. There's a lot of water involved in certain areas, especially in Lone Oak. So there's a lot of settling, a lot of changes that can happen in the ground of your house. But that doesn't necessarily mean there is a structural component that makes it inhabitable, which that goes back into the appraisal thing. But there are repairable and unrepairable standards on appraisals as well. So sometimes you get into a situation where you find out something is repairable, and if you have a cost to cure that's there, you can fix the house.
90+% of foundation issues are repairable.
Yeah. Well, they're repairable in law. They're curable in appraisal. Yeah. So whatever you want to call it.
You can make repairs. Some of them are expensive. I've seen some 6-figure foundation repair issues.
I've seen some 6-figure agent repair issue. I'm just kidding. Yeah. But here's the deal. I think that this was a good example of how the agent was protected, but I also feel like this was an opportunity for growth for someone to look at this and say, okay, as an agent, if I was in this situation, I would take just a couple steps more so that when I'm in court and they say, did you take an extra step? I can answer, yes, I did. What do you think? You're happy with it? Yeah. All the squiggly lines, you have no objections?
I think it's very difficult. It's a difficult situation because as an agent, you're governed by the real estate commission. Your license is.
But as a citizen, I'm governed by the Supreme Court.
Well,
so which one do I listen to?
And that's what I'm saying is that you're governed by both. And in my mind, the real estate commission regulations are more protective. I've started doing this in lawsuits that I file against agents on behalf of others. Is I've started using those real estate commission regulations because some of them are statutes. They're actually listed in the Arkansas Code as to what obligations that a real estate agent has.
Yeah.
And we've started actually listing those out.
Those are hard to argue with, though, because if you cite a statute and there's a clear violation of that statute, then there's a very clear decision on it.
Yeah,
so it's a lot easier.
Very easy to say, you got a license from Arkansas, right? That's governed by these rules. You didn't follow them. And we've started doing more of that, and the courts have started paying more attention to those real estate regulations and the commission rules. And so I think, in my mind, it's even though this case is out here and it kind of gives some freedom of ignorance, it's still not a good idea because the real estate commission is ultimately the one that holds your license.
Yeah, and every time somebody thinks about like the courtroom, I'm sure everyone's like, I plead the fifth, or like, you can't handle the truth. Those are the two. And you can't do that. I was about to say those are 2 instances. You can't mess with that when you go to court on this. So, okay, well then.
You can, but it's deemed against you.
Nobody's going to use you as a real estate agent if you do that.
No.
I plead the fifth. Oh, you're fired. So, okay, well then good. You can rule on this scenario, but I would also like you to throw in there that I get to come over next time you cook a pork butt on the barbecue.
I think that we need to rule that the most important thing for an agent to consider, along with the ethical obligations and all of those, would be to follow the real estate commission guidelines. Even though there is a little bit of a catch-22 between what the Supreme Court says and what the Arkansas law has said, the Arkansas law that's in place right now that governs the licensure, because even if you don't get sued in a lawsuit, you can still lose your license. You can lose your license through a real estate commission complaint that has nothing to do with the Arkansas Supreme Court. And so best judgment says follow those guidelines.
Okay, well, the lawyer says follow the law guidelines listed in the ARC regulations, especially 8, 9, and 10, but the 8s and 10s especially. And then for me, I'm going to rule that if you are a listing agent, get as much information as possible about the property. The more you know, knowledge is power, the better it is. And also, if you have to disclose a difficult defect or something that is materially going to affect the value of the property, price the property for it, show them how you can still sell the property quickly for the right price, even if you consider the defect, because that's going to make you the agent they call back the next time and the next time and the next time. So, all right, rule it.
We got it.
All right, there you have it, folks. Another episode of I Hate Real Estate. Don't forget to smash that button and subscribe, and we will catch you on the next episode. Mr. Grooms, I'm off to cause trouble.
Thanks.
Call you when I need to get out.
All right, I'll be there.
it.